Act discussion with the commission. Thanks for coming. I'm going to start with Commissioner Hinkle.
Yeah, this is the third meeting I think we've had on the compact and this bill, first one for this bill. And, you know, it's so complex that I don't really understand it, and I don't think a lot of people understand it. But one of my main concerns is the CSKT County MOU they had with their tribe there, which is a Salish tribe, and they ended up getting a moratorium on all new wells being drilled. And I was concerned that maybe that could happen here, that they could, through the inflows, the whole thing is controlled by the inflows. And so somebody can say, well, those inflows aren't enough, so they put a moratorium on the wells. Over in CSKT County and Washington State, they, you know, it's been on there for like, I don't know, maybe 10 years, 7 years, 8 years, something like that. And I was concerned about that. Then I was talking to Patty, and she made me aware of the concern that maybe one of those lower Columbia tribes or senior water right users could make a call and basically shut down our senior water rights users. And so those are a couple of questions that I have, and maybe we can get some answers if you guys have questions. Juan Catlett, the guy who put it together, Daines' bill, is supposed to call in at 1:15 and to answer questions.
So I haven't totally done all the research on that question. That's a good question.
Did you look up that zoning stuff or anything, or have you had time?
No, I don't.
I just wanted to make
I don't know what that zoning as far as federal law. I'm not sure that.
What was on the water, how they would get the water and how much water they could have and that, but there's only so much they could have in that certain bit. The way I understand it, maybe I'm very wrong.
That's good. I mean, I think.
Yeah, we talked about this
legitimate.
Earlier this morning, and you were going to look up some stuff, and you didn't get a chance to do that.
No, I haven't. Yeah, meet with people here, but yeah, we could. And if you don't have all your answers today, you can put it on till or continue it until next week. Yeah.
So you guys.
I do know that the section 10 talks about 10D, effective compact and act. Nothing in the compact or this act, except as otherwise expressly provided in the compact act, reduces or extends the sovereignty of any government entity.
Ron?
Hello?
Hey, Ron?
Hello?
Hello, is this Ron?
No, this is Eric Best with Kennecott Exploration Company.
Yeah.
Hi, I was calling, I had sent this is the Granite County Commissioner's office, is that right?
It is, but we were waiting for another call. Can I get your number and call you back?
Absolutely.
Okay.
Phone number is 801-363-5870. And this is following an email that I sent to the Commissioner's office back February, 2-3 weeks ago.
Okay.
Exploration stuff?
Yes, sir.
Rio Tinto, okay. We'll call you back.
Perfect, thank you. Bye.
Thank you. Sorry.
It's on that exploration.
Yeah.
Green creek and stuff, we can call it every year.
So you guys want to say something?
Well, I think one of the good things is that, like Commissioner Hinkle said, this is a complicated bill. Initially, CSKT passed out of the legislature. We were told that it couldn't be changed, that it had to be accepted by the Senate the way it came from the Montana legislature. Senator Daines said no, you know, he can change anything he wants to. It's going to be his bill. Senator Tester actually submitted this bill a year ago, over a year ago, the way it came from the legislature. And because of the time that passed and they didn't act on it, it had to be renewed. This time Senator Daines did the research and tried to effectively help the bill, fix the bill. It's certainly not perfect, I would admit that, and it's certainly complicated. But what we tried to do is put pressure on Senator Daines to consider the off-reservation water rights, okay? What they do on the reservation, don't care. The trains left the depot on that. Probably none of my business. But what is my business, what's all of our business, is the people that we represent in Granite County in the Flint Creek Basin that have water rights. So we started saying, look, is there any way you could, because we were going to lose those rights basically, in a appendage of the original bill, 28 and 29, if you look it up, it basically, and it names this basin where we lose the power of our water rights. They do take them away by how old your right is, how young your right is. In other words, the younger rights go first. If there's a drought, they call on the younger rights than the older rights. But they could call on all the rights if they wanted to, under the old CSKT. So, didn't hear anything after we made a plea to him to look at off-reservation water rights. Representative Gianforte came, sat right here. We asked him about it. He said, we're in the middle of negotiations with the tribes. We do not want to talk about it, but he did say quietly that we're going to try to buy your water rights. Because what's in the initial CSKT agreement that the state passed, that's the only way we're going to get it. And I'm like, what the heck was that? So when I saw Daines's bill, which is different than what was passed out of the legislature, different than what Senator Tester had proposed over a year ago, quite a bit different, but it does address off-reservation water rights. And what it says essentially that I liked was that the tribes are going to have to relinquish all claims, there's some wording there, but basically give up all the off-reservation water rights except for a very few, 3%, that have real young 1968 or newer dates. Okay, so the old water rights were protected. Now, talking to Chuck and his concerns, I agree with that. But here's where I think we have some protection: is that in that same section 10, part 4, I think it is, where it talks about off-reservation water rights. It says that these rights, or these relinquishing these rights from the tribe, are without prejudice.
With prejudice.
With prejudice.
10A1.
Right. So with prejudice means that they can't come back. They're done. It's the decision. So if they go to court and say, we'd like to do something, they said, no, you've already given those up. Here's your signature. And so in perpetuity, forever. Okay, and I think that's significant. The other thing I think that's in the bill that makes it easier for us, and like I said, this is not perfect, but it's a hell of a lot better than it was when it came out of the legislature, is that if there are water right disputes in this basin, okay, off the reservation, in this basin, in the other basins off the reservation, those disputes will be held or dealt with in state court, not federal court. So the tribes have, because they're a sovereign nation, they have to deal with everything in federal court. That's a game they play. They pull you into, and you can't afford to go to Seattle and make a case, you know what I'm saying? But they would have to come here, and maybe likely in this courthouse to start, to make any kind of claim or adjustment to what this bill does. I'm going to say it again, it's not perfect. But guys, when I look at it, I didn't know that we could fix it in the first place. And thank God Daines got in and said, yeah, we're going to do the very best we can. Now, did they buy the water rights? Well, remember out of the state court, out of the legislature, the original CSKT gave reparations to the tribes of $55 million and some property. Well, now it's about 1.3, is it 9?
1.9 billion.
1.9 billion with a B, and they get the bison range and some other stuff.
A managed device.
Yeah. So they effectively turn it over to
Yeah. Title remains with the U.S., but they have all basic.
They basically run it. All right. So, did they buy them? I'll leave that up to you. My guess is, yeah, they bought them. They bought our water rights. Off-reservation water rights. You know, I know everybody can have a problem with that, but that's the bill. And that's where we're at today.
I didn't know they were for sale.
I'm hoping Ron will come so we can get on here in a minute. He should be here in just a minute. So you could ask specific questions to the guy that did the research and help Senator Daines get to the point where we are right now. Okay?
Can we talk at all?
Sure.
Can I come up and talk?
Absolutely. Do you want to wait till Ron's on the phone, or?
I can do it right now, real quick.
Okay, come on up.
Okay, I've been studying this thing for weeks and weeks. My eyes are tired.
Could you say your name?
Oh yes, Patty Kentridge. And through this,
She's got one.
oh I've got, can you
Yeah,
not
turn it
hear
on.
me?
Yeah, no, turn it on, it'd be good. Just push it straight up.
Okay,
and
do I?
Just hold it up here.
Okay. Can you hear me?
Yep.
Can you?
Yep.
Truth is, I have great sympathy for the Indians, listening to this treaty, how it was put forth. That Isaac, I'm going to call him Isaac Newton, but I don't, it's Isaac Stevens, the governor. Oh,
I'm going to see if this is him. It should be. Ron?
Hi, Bill.
Hey, Ron, this is the full commission. We have some public members, and Patty Kentridge was just up starting to speak. We're going to let her speak, and then you can maybe answer some questions, okay?
That's fine, yeah.
Good, hope you can hear.
All right.
okay.
Sounds good, Bill.
Thank you.
Well, I am totally against the water compact. They do not have water rights, and I'll prove it right here. I like the People's Water Compact because it's solely Winter's Doctrine, you know, on the reservation. Now, the whole thing that's given the Indians, they think they have the water rights, is because of something that was written in the treaty that Isaac Stevens put out. It was about guarantees tribal members the right to fish and all usual custom places. And I have it right here. And I can't believe this is morphed into something so big. It says right here, as also the right of taking fish at all the usual accustomed places in common with citizens of the territory, and erecting temporary buildings and procuring, together with privilege of hunting, gathering roots and berries, and pasturing their horses and cattle upon the open land that was unclaimed. Now, bureaucrats in Montana have taken this to mean all of this territory here. But guess what? This treaty that Isaac Stevens put out, he did it with 9 different tribes from here out to the Pacific coast. All these tribes have exactly the same wording. And they were wondering what that meant, you know, that fish, the territory and all that. Well, tribes prosecuted several lawsuits to defend and define the treaty fishing right, culminating in the landmark 1974 decision in which the federal judge George Boldt famously interpreted the treaty provision, taking fish at all usual and accustomed places in common with the citizens of the territory, to mean it was meant the annual salmon harvest run must be shared equally between the Stevens Treaty tribes and non-Indians. It had nothing to do with waters off the reservation. It had to do with salmon fishing. And if you look at Isaac Stevens' notes and stuff, he wanted them to be able to fish. But our bureaucrats have used this one little paragraph to say they have water rights. Now, I went through all the court of laws. This has been tried in 3 or 4 different states. It was tried in Wyoming. The Wyoming state said, no, you can't. You can have fishing rights, but no water rights. Now, it was tried a while ago in the Sun River Basin Adjudication Court. The Nez Perce, they wanted water rights, in-stream flow. But because the people knew the meaning of the treaty, this is what the court said. If the state could regulate and provide for the survival of fish, then there need not be any in-stream water right belonging to the Nez Perce to do the same. Now, all the courts from here out to the Pacific coast, and there's been a lot of this tried, they always brought in Isaac Stevens, what his intent was. He was totally manifest destiny. He wanted the Indians gone, and he wanted the settlers to come in, and they were to have the water rights. Now right here it says, this is one of the circumstances they used in the court. Stevens' treaties were intended to resolve disputes over land open to settlers by the Oregon Donation Act of 1850. The SBR, that was the Snake River Basin Adjudication Court, thought it inconceivable that the Nez Perce would have been permitted to reserve in-stream flow for water appertinent to lands not on the reservation and lands which were to be settled. So they always brought Isaac Stevens in to prove that wasn't the intent of the treaty. Montana's the only one that says you can have it. And it's wrong. They misinterpreted that one little deal. It was about salmon fishing. It wasn't about water rights through the whole deal. But that's just what I wanted to point out. And I think we need to really push for better understanding of this treaty. I think I think bureaucrats and liberal judges have tried, and it's just not being brought out. And I'm very concerned.
But I'm not correcting it because I agree with you, but Dick and Elena and I and a number of water users went to the legislature where this exact argument was presented.
Well, was this
Eloquently,
about
yes,
what it meant?
Because the legislature was the first body to act.
Yeah.
And it's not a court, they make law, okay? It's not a court. They can change the law, and they did. And, you know, this whole thing was heard around the state, and then finally it got to the legislature. And there were, is it 11 people on the subcommittee? I think it was, that heard all of us for days. Dick and Elena testified, we testified. We went, there were a lot of people here from this county that testified, but on the same issue, okay? And there were Indians that got up and testified that, yep, they're right. They shouldn't take, I mean, there were people on our side from the tribe. So 11 people decided 6-5 to kill the bill. Then what happened was, have you ever heard anything called a silver bullet? I'm still confused about that.
No,
It's a legislative rule that allows them to take something out of the subcommittee and fire it right into the House of Representatives.
No.
So they did that. They exercised their silver bullet, which, okay, now that's really scary to me. So 100 people in the House of Representatives voted on a bill they heard no testimony about. Never. And these good people listened for days, didn't they? And they heard everybody, and they were great people. They were kind to us. They took everybody's opinion, both sides, okay? Their vote to kill the bill in committee was overruled in the House of Representatives. Now that's law. That's law. The next step, though, was it had to go to Congress, okay? So that's the step we're in right now. And so, I don't know, it scares me. I thought that we were done, okay? But Senator Daines, when he got an opportunity, made some modifications the best he could. Did he buy their water rights? Probably, I don't know. But I mean, he looked in, and Ron's on the phone, and maybe you could help us with what happened when you guys took this thing up.
Yeah, so, yes, you know, the compact, my name is Ron. For those in the meeting there, my name is Ron Catlett. I'm with Senator Daines' office. I'm a field representative based in Kalispell, and I have been, I cover Lake Sanders, Flathead, and Lincoln County, so I've been working on this issue for a couple years now. And so I guess, yeah, so Bill, you're correct. The bill, you know, for better or worse, I think, you know, you can go back and argue about whether or not the compact should have passed the state legislature.
It did pass the state legislature, and that was what was, that was what was given to us to deal with back in 2015. Senator Daines did not. Senator Tester in 2016 introduced his bill to ratify the compact. Senator Daines at that point did not support that effort because he wanted to study more, talk to more people, figure out what was, what were the real impacts of this compact, and what are the what are the consequences. He was particularly concerned about the impact of off-reservation water rights, and then of course and then impact on the water users on the reservation who are not members of the tribe. So it's been a several-year-long process with the senator. Long talks with the Trump administration, attorneys from Department of Interior, Department of Justice, the tribe, of course, discussions with local irrigators in the Flat Irrigation Project, county commissioners, state legislators, and then also even our own congressional attorneys. We've even talked to private water rights experts, water rights attorneys, to get their take, just to kind of figure out what the what the best path forward for this would be. And so one of the and in the meantime, the senator, in negotiations with the tribe, did secure, I think there were some important changes from previous proposals, and I can list those if you'd like me to. I mean, the tribe did agree to relinquish off-reservation water rights in the Flathead Basin upstream of Flathead Lake in the reservation. We took language out of Senator Tester's bill that would have required all water rights disputes arising under the compact to go to federal court instead of state court. We definitely believe that folks need to be under as much state jurisdiction as possible in this process. We got changes made to the way that the water management system would work on the reservation, which I know doesn't necessarily apply to Granite County. But I think one of the big things that the senator had was questions he had in this whole thing was, we want this settlement when it's passed to be final. We don't want the door open 10, 15, 20 years down the road for this to come back and be relitigated. So one of the changes that we did secure from the tribe was so I have the bill right here. The tribe shall execute a waiver and release all claims with prejudice or water rights within the state that the tribes or the United States acting as trustee for the tribes asserted or could have asserted in any proceeding, including a state stream adjudication. So that language, with prejudice, is a legal term, means that if you release something or give up something with prejudice, or a judge rules with prejudice, it means that it can't go back and be done again. If you say without prejudice, it means that question could come back again. So that's an important change we got to make, and I think that's very important for folks in a place like Granite County, which is west of the divide, and which a place where the tribe has filed, a lot of water rights claims. And I think so it's very important to keep that certainly in mind as we discuss this bill. Now, I'll say, and I know that the lady who spoke before mentioned several water rights cases and different ways of looking at that language in the Stevens Treaty or the Treaty of Hellgate. And I'm not a lawyer myself, but I will say, particularly recently, we've had a couple of different we have a couple of different court rulings that have upheld, tribal Stevens Treaty water rights off reservation. We took the People's Compact proposal straight to Secretary of Interior David Bernhardt, who is himself a water attorney, and he gave us a letter response back, and he pointed out a number of different cases from, I'll just read a couple of them here: Kittias Reclamation District versus Sunnyside Valley Irrigation District, United States versus Adair, or a couple of them. We have another case of the Klamath decision, which some of you may have heard of recently, unanimous federal circuit court decision out of Washington, D.C. The folks in the Klamath Basin fought the tribal water rights claims for almost 20 years and lost. So all the information that the senator was getting, as we dug more into this issue, and all the advice we were getting both from the administration and then based on where the federal courts were ruling. And at the end of the day, folks got to remember, when a federal court rules on a treaty, there's not a lot that Congress can do at that point. The senator decided at the end of the day, we have a situation here where he felt like this was the best deal for Montana with the changes that he secured. So the tribe filed, of course, 10,000 plus water rights across 2/3 of the state, all of western Montana, under this deal, the tribe does relinquish, 9,981 of those claims with prejudice, and then they retain 217 water rights on the reservation, and then there's 59 off the reservation, and a handful of those are in your area. The Milltown Dam right, which impacts, I believe, Flint Creek, and then the Rock Creek drainage as well. A handful of water rights there. But at the end of the day, rather than, if it's went to court, we'd have thousands of Montanans that would have to retain lawyers and fight these water claims. And like I said, the other areas, this has taken, decades to settle. And high legal fees in order to settle this, and the senator thought it was more prudent to put forward a proposal for to settle this. Another important thing to point out here is that after the tribe filed its claims, the state passed the compact, the tribe filed its claims. The water court in Montana put a stay on adjudicating the tribe's claims, while the federal government had to give Congress and the federal government time to do its own homework and come up with a settlement. And so the water court has been staying these rulings. The last stay was due to expire on January 10th of 2020, and so the water court judge had indicated that if he didn't see significant progress in legislation introduced, he was probably going to lift the stay, and we would be in court at that point. So the Senator Daines' bill was introduced on December 12th, and the next day the water court stayed, extended the stay for another 3 years. So again, seeing that progress made, legislation introduced, and give us time to pass the bill. So that's where it stands from Senator Daines' Senator Daines' perspective. His thinking, why he decided it was time to move forward. And with that, I'll open it up to if folks have any questions for me.
Ron, this is Chuck. You said the Flint Creek and Rock Creek are into 3%?
Yes, so there's, let's look at the chart here. So there's a handful of water rights. I don't know the exact number. It's about 6 or 7 on Rock Creek in Granite County. Very important though to point out that those are already existing water rights that state FWP owns, and they have a priority date of 1971. Correct me if I'm wrong, I don't know of anybody up there who's irrigating water, using water for irrigation with a priority date of higher than 1971. And again, this is an existing water right. The tribe just becomes co-owner of the water right with FWP. Also very important to point out, and I should have said this earlier, for folks who are worried about private wells or municipal water systems, Article 3 of the compact, which would be part of the Montana Water Rights Protection Act, says that the tribes, on behalf of themselves or users of any portion of the tribal water rights set forth in this compact, and the United States agree to relinquish their right to exercise the tribal water right to make a call against any water right whose purpose does not include irrigation. So, if you're not under the compact and under the Montana Water Rights Protection Act, if you're not irrigating with your water, if it's just a private well, your municipal water system, the tribe can't exercise a call on your water. It would just be for irrigation wells with a flow rate of greater than 100, I think it's 100 feet per second or something or 100 gallons per minute. That's what it is. And then Rock Creek is part of the Milltown Dam water right, and that one is a priority date. It's already existing under state law. The state owns that water right currently. The tribe just becomes the co-owner of that water right under this bill. That priority date is 1904. The research that I've done shows me that there's about 1,900 water rights in both Granite and Missoula counties along that Milltown Dam water right, and 1,700 of them have a priority date earlier than 1904, so they would not be impacted. But again, this is not a new water right. It's already existing, held by FWP. The tribe just becomes the co-owner of it.
Right, thanks.
Yep.
Are you aware of the Skagit County and Washington State, and the state did an MOU with the Swinomish tribe there to control the inflows of the Skagit River? Are you aware of that?
Vaguely.
Well, you probably should study a little bit, because I can't see any difference between the state and the tribe controlling Rock Creek and Flint Creek as the Swinomish tribe and the state of Washington controlling the inflows of the Skagit River. And in the Skagit County, for like 10 years, I don't know, 8-10 years, they have had a moratorium on all new wells. They haven't drilled a new well. Okay, and that is in co-ownership between the state of Washington and the Swinomish tribe, which happens to be a Salish tribe. Okay, so why is that different than what we're doing here? I mean, so we're going to have the state and the tribes co-own the water rights in a 3%, and that's exactly what happened over there in Washington State. And they haven't drilled a new well because they control it. They didn't go after the individual wells. They went after the inflow to the streams. And it's really hard to prove what the inflow, I mean, if not impossible, what the groundwater is to the inflow of Skagit River or Rock Creek or Flint Creek, okay? So could this happen to us? Could they put a moratorium on all new wells because of the inflow? And they didn't do this right away in Washington. They waited, several years, 5 years, whatever, 6 years, something, because everybody thought, well, that's what they're going to do. And before they put the moratorium on the wells, they said, okay, we won't put a moratorium on the wells if we can meter your wells. Okay, are they going to do that here?
Okay. So, you know, I can't predict the future, but I will say I don't believe this is the case for several reasons. First of all, you know, we have this is a water compact and a federal settlement, not a simple memorandum of understanding. I also think that I mean, again, you have, you know, the tribe and the state and the federal government all agreeing in federal state statute, you know, this is how this is going to be. And so, you know, certainly a lot more force of law than, you know, a memorandum of understanding. I think the other difference there, I would say, is that it sounds to me like those were new water rights that were created by those memorandums of understanding. These aren't new water rights. These water rights have already existed. The same, you know, they're held by FWP currently, and so I don't believe there would be the same I don't believe there would be the same impact.
Yeah, but should the people here, our irrigators and whatever, go on just what somebody thinks? I mean, is there a chance?
Well, I mean,
if there's a chance this is going to happen, I mean, this is their futures, this is their livelihood, and what's to prevent? I mean, they can do it right now, but in this bill, there should be something to prevent somebody from the lower Columbia Basin making a call on our irrigators. Because
so that's not possible, because so, you know, Montana, Idaho, Oregon, and Washington have, you know, they you know, have kind of a compact amongst the states, a water use agreement, and each state impacted by the Columbia Basin has, you know, a certain amount of water that it can use and is entitled to, and so these tribal water rights, or, you know, or the tribal water usage rights fall under those state allocations. So you can't call, so a tribe in Oregon can't call water on a tribe in Washington, or a tribe in Idaho or Montana, or can't call water on a tribe in Oregon can't call water out of Montana, because as long as Montana is, you know, within its water usage quota, or whatever you want to call it, you know, that can't happen.
So you're saying they're not connected. The senior water users here are not connected to the senior water users there.
No, because they, you know, and the state, these are state-based water rights, and so each state, again, has its own, you know, allocation of water that it can use within the Columbia Basin. And so, provided, you know, the state is not using too much of its water, then, which would have to be handled at state level, if that were the case, you can't call someone in another state.
I don't disagree. This is Blaine Bratch, the county attorney. I just haven't researched that point, and I can research that and do a memo for them on that point. The other issue, I agree with you on the federal law is going to trump. My understanding of what happened in Skagit County was a state law issue, but I need to double check that as well. So I think it may take care of both of those concerns.
Okay.
So, Ron, just for clarification on something that Chuck just was talking about, the state of Montana and the tribes co-own only those water rights that the state of Montana's had anyway, on Flint Creek and Rock Creek, right?
Right, yeah.
Okay, so that's 3% of the total water, so the state does not control the water in Flint Creek and Rock Creek. The biggest majority are those old priority date irrigators, and I don't know about Rock Creek, but I do know on Flint Creek, the youngest water right is 1968. They're all older than that, and there's just a few of those, like 3 of those 1968 water rights, okay? So controlling those two streams, you know, with all due respect, I think that's not a good term.
On this new law is not, making them a co-owner of it, but the state already has the right, so.
Yeah, it's
This
like-
isn't gonna affect
Right.
the state, well, I mean, I guess that co-ownership could create some money to
I don't
water.
think so, because the state of Montana owns all the water. We just have rights at points out to irrigate.
But, yeah, what he's saying is the Fish and Wildlife Park has the rights on that already.
Exactly. That's it.
Yeah, and our bill does, one of the things, our bill does recognize, Article 9, Section 3, the Montana Constitution, that the state does, ultimately, at the end of the day, the state owns the water.
Right. So, we've got some other folks that would like to make a point.
Yeah, my name is Barbara Clark. We have a small family ranch on Rock Creek.
Hey,
This-
Barbara, would you use the mic? So, thank you. Just,
I think it's on.
yeah, I think it's on. Thanks.
All right, I have a couple questions for Ron. I want to know if the compact has been modified in any way, or is it intact?
Did you,
So the underlying compact, that deals with the water rights and the unitary management on the reservation and that sort of stuff, is intact. The changes that we were able to make are from the previous Senator Tester's proposal, and then some additions for greater accountability and clarity in state jurisdiction were being made through the federal, through the federal settlement side of things. We kind of like Bill said, without it, there weren't very many. I mean, we can't change. At the end of the day, we can't change the fundamentals of the compact that passed the state without it having to go back to the state. And so to answer your question, yes. I mean that the main body of the water compact is left in place.
Correct.
But there were some, like I said, clarification changes, like with prejudice on the relinquishment of the claim, and then state jurisdiction in the unitary management board, the removal, letting things go to state court. That's all stuff that we could do within the federal legislation.
Right, you could do. But so the compact is as it was passed. So the act is a different thing. And the act came to be when the Indians filed on 10,000 water rights. That's what they're dealing with. They're not dealing with the Clark Fork Basin, per se. That is intact like it was in the compact.
Yeah, well, so I would say you got to remember that the tribes filed those claims, in the Clark Fork and across 2/3 of the state, and under the compact, they agreed to relinquish. Again, it's the 97% of their 10,000 water claims, and there are a handful that remain in the Clark Fork. It is the same as the state passed compact. It just we have that language in there that they're being relinquished. Claims that are being relinquished with prejudice.
Right, but the claims that are being relinquished were filed on after the compact was passed.
Yes, that's correct.
Yes.
Yes.
Okay. So this is not going to help Clark Fork Basin out at all.
No, I would disagree because
I think she misunderstood you. What she said was, say it again, these claims were filed after the compact. No, in the original compact, the tribes filed against all those claims in this basin.
In the Clark Fork Basin?
Yes.
Correct.
Yeah.
They filed after the compact was passed.
No,
then they
no,
turned
no,
around
no.
and
The western part of those were the legislature passed all those. We were going to get appendages 28 and 29 of what the legislature passed. We lost our water rights.
right.
So that's
lose the
not
water rights?
what he's changed. What Daines has changed is that.
No, he has not. He has not changed the compact.
No, he's
No,
going
Bill,
to modify. He's going to modify.
Bill,
Yeah, I see.
So the tribe passed. the tribe passed, so she actually is correct.
I am correct.
I agree.
Oh, thank you.
The tribe passed the state, and so the tribe said, we believe we have water rights across two-thirds of the state, our ancestral homeland. And so the tribe and state negotiated the compact, and went to the legislature, and it passed.
Yeah, I agree with that.
But then what the tribe did is the tribe went to, so then once it passed, the tribe said, okay, now we're going to file those 10,000, we're going to file 10,000 claims across the state, and we're going to stay those, and during the federal process, we're going to stay those under the federal process, and let the federal process play out, and then of course if the federal process breaks down, then we go to court. But under our bill, so I think the important thing is that they didn't file the claim before the federal legislation passed, because in Section 10, the bill says, right, so in Section 10, the bill says, where is it here? It says, hang on, just let me get it here. It says, the tribe shall execute a waiver and release all claims with prejudice for water rights within the state that the tribes or the United States acting as trustees for the tribe asserted or could have asserted in any proceeding, including a state stream adjudication on or before the enforceability date. Except to the extent that such a right is recognized in the compact. So the compact recognized a handful of water rights along the Clark Fork, and so those would continue, again, co-ownership with the state. And but all those hundreds of water rights claims the tribe has filed on individuals and others would be relinquished under this bill.
Those were passed
With
after
credit.
the compact, right. Those were the additional 10,000 that they filed on. That does not.
And they waive it under this. Yeah, under that language they waive it.
Right, they
Yeah.
waiver it,
Yeah.
but we are not released from that. Clark Fork Basin is not in that.
Those, the
No,
ones you
Clark Fork
mentioned
Basin
before,
is.
the ones that.
Clark Fork Basin
That's
is.
across, 10,000 claims are done across the entire two-thirds of the state that CSKT claims says is their ancestral homeland.
Only the
They're
limited
just
ones
retaining-
remain.
Yeah, they're just retaining a few limited ones, in the Clark Fork, and then there's some up in the Kootenai, and down to Bitterroot.
They're the ones that were passed in the compact. So the compact has the last word, and that is how it is. Now, you're talking about rights that, water rights that precede 1904. But isn't it true that Indians have a water right that goes to, it goes over to the Cabinet Georgia Dam? Did they just acquire that in 2015?
So you're talking about the part of the water right on the Clark Fork, where the Clark Fork leaves Montana.
Correct, yes.
Into Idaho. Yeah. So I think it depends on. I think the tribe would say that they've had that right under their treaty. Going back to when they agreed to the treaty in the 1850s. But in 2015 was when the state agreed to recognize that water right. So it would, again, it would not have to be litigated in court.
Right, they were trying to appease the tribes, I believe. Okay, so it says that there has to be 5,000 CFS. That's the maximum, the flow rate of that.
The minimum flow
Yeah,
rate.
the minimum,
Yep.
yes, the minimum. Okay, it doesn't look very comforting that the minimum flow rate has almost been met quite a bit of the time. Well, it's,
I'm sorry, can you repeat that?
okay, I said the minimum flow rate, I've got a chart here, then it looks like it has actually dipped down even under the 5,000 CFS. So if that happens, then the Indians can call on the water, and it doesn't matter if you had, I'm sure they're going to start with the junior water rights people first, but the senior water rights people are not protected under this because they have a time immemorial priority date.
So yes, they could call water, but again, it can only be irrigation water, and it only can be water irrigated out of the main stem of the Clark Fork River. It's not enforceable against tributaries.
All right, that's clarification. However, if the water does at the Milltown, you know, if they could call water on Rock Creek to make sure they have enough going through the Milltown site. Is that correct? On a junior.
There is a chance, yes. But again, as I said earlier, you know, the vast majority of water rights are seniors 1904, so they would not be impacted. But you know, there would be a handful of yes, I mean there would be a handful of water rights users who could be impacted. But again, kind of getting back to my earlier point, the Milltown Dam right already exists, and it's owned and managed by, you know, it's owned by the state. So there's nothing, I guess there's nothing new attached other than just CSKT, you know, co-owning that right.
Right, the state's going to give it to them. Yes. I certainly don't think this is a good plan. It really is going to gut Lake County, and it certainly is going to affect Granite County. I hope that people can stop and read this and understand it, or try to understand it. And I really think that I would like to see Mr. Slaughter's letter withdrawn, the support that he gave for them.
Let me ask you a question. Do you think the people in Granite County are going to be better off with the tester bill, the way it came out of the legislature, or with what Senator Daines is trying to modify the CKSD water agreement?
I don't think they're going to be better off with either bill.
Well, we fought, okay, I fought hard CKSD.
Right.
I was against it.
Right.
But you didn't answer my question. You know, it's law. It's passed. The train has left Montana. They're actually dealing with it on the federal level now. Should we just leave it alone and let Tester's bill be ratified? Or should we go with Daines' modifications that relinquish 97% of the off-reservation waters in Montana? You don't see that's a better alternative?
So we're going to get thrown under the bus?
We already have been.
Okay, so
Yeah.
the rest of the state's going to throw us under the bus?
They did. I was
Yeah,
there. You
I
guys
realize
watched
that.
it.
I know
Yeah.
that.
Yeah, that's done.
But the two wrongs don't make a right.
No, but what's better though? The original water compact or what Daines tried to modify this?
I think we need to fight this. I think we need
We've been
to.
fighting it.
I know, and I think we need to continue.
Okay, so let me ask you, what's the next thing? It's in Congress.
Yes.
The president said he's going to
We
sign
need-
it. Daines has got the
Now,
bill
I
up
don't
there.
know that the president said he'd sign it.
Ron, the president said he'd sign this, didn't he?
No.
No, to be clear, he didn't say
No,
like
he
I
never
will.
said-
No, but I mean, he's for,
No,
he's
no.
supported, the administration is
We have-
supporting, yeah.
Yeah, the administration is supportive, yeah.
So we can say, we need to fight this, how do we do it after it's already left Montana and is in?
Well,
how do we
I
do-
agree, it's going to be very hard. Yeah,
But
but
if
this is
you got a
wrong.
mechanism, I'm
This
your
is
guy.
wrong to the core. This is
Yeah,
wrong.
But my point is, Daines' modifications are so much better then what we
How
were
are they
facing.
better for?
Unless you're on the receiving end of it.
Yeah, unless you're on the receiving end, it doesn't really make it,
I have water rights personally in Granite County.
okay?
And they're old whites, and they were gonna be gone anyway. But at least Tester's gonna try to protect me, because I'd be part of that 97%.
No,
Or excuse me, Daines, I apologize, Daines.
wait a second, your water rights are where?
On Flickr.
Then how, they are not going to be, they're not in this 10,000.
Yes, they are. Ron, you
Yes,
need
they
to
are.
explain, yes, they are.
Okay, how, can you explain
Yeah,
that
but
to
if
me?
they made a call on that creek, you are all junior, everybody's junior to the tribe.
No,
That's
that's
not
not,
correct.
that's not
That's-
correct.
That's
The
true.
Flint Creek-
It's the tribes
Flint
that-
Creek water rights,
Yeah.
priority date are 1971. So
Tribes.
Bill, I mean, assuming your water rights. on Flint Creek-
1873,
Yeah, what was 1873?
yeah.
So that's one of the things the tribe in the, in their discussions and in negotiations, not only a small handful of the tribal water rights are time immemorial. The vast majority of these water rights, including all the water rights that they would be, so all the off-reservation water rights that the tribe would get in Granite County are co-owned with the state, and they are priority date, in Flint Creek, 1971, priority date in, Milltown Dam, 1904.
And what right do they have to do this whole bill then, if they're not time immemorial?
They,
I don't understand.
that was part of their agreement, so, they, I guess when the state and tribe came to the negotiating table, the tribe said, here's our water rights, here's what we think we have, and they said, we have time immemorial rights for in-stream flow fisheries across our ancestral homeland, 2/3 of Montana, including, including Granite County. And so then the state came back and negotiated, and the tribe agreed to only assert time immemorial claims over a small handful of those water rights. And then, then the compact, went through the legislature, and now it's to us, and we've worked on it. So, so at the end of the day, and I think, it's the other bill, one other point of clarification to make is that, you were mentioning Senator Tester's bill. If that, Senator Tester's bill is one option here, but the other option would be, if Congress doesn't take action, if the Congress doesn't take action, this is going to end up in court. And you have to, again, it would be fought out in water court. And even if the Montana Water Court, even if the Montana Water Court were to side with, non-tribal water users, it would still probably end up in federal court, as what happened with Klamath. And I think, kind of to go back to, Attorney General Bill Barr was asked about this when he was in Montana back in, I think it was November. And, he emphasized, folks shouldn't think they're going to get a better deal out of litigation. So, so in addition to Tester's bill being an option, the other option would be then to let this all get fought out by judges and courts and attorneys.
All right, I'm a little unclear of this, the act that is going to relinquish 97%. I understand that. But that doesn't include, the protection that Mr. Slaughter has is that he has old water rights, and he has a senior water right, not a junior water right. That is in the compact itself. That doesn't address it in the act, does it?
So the act, so the act confirms that aspect of the compact.
But it's already in the compact.
And then adds the language that and then adds that key phrase with prejudice. The claims are relinquished with prejudice instead of without prejudice.
Okay, what?
But it was the state passed compact that that came up with co-ownership and the 1971 priority date.
I'm still, I mean, I guess I'm thick today because I'm still not understanding that Mr. Slaughter's water rights were not they're not, the only reason they're okay is because they have a priority date.
No, the other reason, if this passes,
Yeah.
what makes it better is that it's without prejudice, which means they can't come after them with prejudice. I'm sorry. That means they can't come after them with court. And all of my neighbors up and down some water rights in the lane finally are protected, because the deal was this passes anyway, and they can come after our water rights, and we've got to go defend them in court. But with Daines's changes, we don't. They're protected. They are with prejudice.
And there's still some junior rights out there that are still there.
Right, but I'm talking about the old lake.
Yeah.
And I think that's what you're talking about, is the old rights, yeah.
Mm-hmm.
No, it's significantly different and better is the way I'm seeing it.
Yeah, well, I don't see it, but maybe I need to go and read it more.
Well, I mean, it's confusing, trust me.
Well, it
I
is
needed-
very
I
confusing,
needed
but-
people, I talked to Jeff Senator Daines yesterday. I need, and Ron has been very good about, what is the difference? How does this help us, okay? Is it perfect? No. It was against the whole, but you know what, we've got to take the best of a really bad deal, I think. And that's what my article said.
Yeah, I don't like to take the best of a really
I
bad
know, I don't
deal.
either,
I
but
think
what
a
choice
bad
do you
deal
have?
is a bad deal.
Tell me what the option is then.
Yeah.
If we don't take this deal, what's our option?
Well, I don't know.
We go to court.
And maybe that's where we should go.
Maybe, but-
we should settle it on laws and
But that
not
doesn't mean you're gonna win,
emotions.
it could be worse. Remember what Barr said. Don't think you're gonna get a better deal by going to litigation. And by the way,
And that's
we
what-
have to
that's
pay
what the
for
folks-
this. We
And
have
that's
to
what
pay.
the folks in the Klamath, like I said, going back to the Klamath decision, 18 years, millions of dollars in legal fees, and the tribe won everything.
And I respect what you're saying, because I'm right with you. The truth is, I'd rather go with the devil I know, not the one I'm wondering.
Yeah, I
Who's
think
gonna hit
it's
us?
a really, really bad deal. And it's going to impact us. We've got a 1897 water right, and then we have some 1917 water rights. So we're junior. We could get our water shut off. This will impact us.
Your old right is pretty well protected, but the
Yeah.
other right, the
Yeah.
other right.
They can call on our water,
Yeah, but
and then
they,
we wouldn't hear
but they
it.
can right now.
Yeah, if it's right by parks, can.
Exactly, they can right now.
And, here, let's go right back to the state of Montana. The water was the state of Montana's. How did we get in such a pickle that we give Forest Service a compact? We give water rights to the Fish, Wildlife, and Parks. We need to protect our water.
That's right.
Were you, 2 years ago, at the legislature testifying?
I wrote letters, I backed
God
it.
bless you, because
Yeah.
we all had this same argument
yeah.
right in public.
I know.
And this county commission, absolutely, we were over there,
Yeah.
okay? Elena was there, Dick was there.
I know.
They made great points, and our own legislatures who screwed us.
Oh, I know, I know.
But now that's gone, that's law, we're moving ahead. What can we do with this ugly thing to make it a little bit better? And then Daines came along and said, I'll do what I can to make it better on off-reservation waters. That's kind of where we're at.
Yeah, the remedy is litigation.
Yeah. Well, here's a question I have here. How did the Indians, the tribe, file on 10,000 claims over the state when they are off reservation? They didn't live there. How can they have those water rights? How can they claim those water rights?
I don't agree with this, but in the legislature, the testimony, Elena, was that they had fished there or hunt there, and there were archaeological finds on those. Isn't that what they said? That's how they claimed that.
So use.
I'm waiting to get up here.
Yeah, they said they used it and fished there.
Yeah. Well, I sure can't have a water right unless I've got the land to irrigate
That's
with.
right.
So, I mean, I just think that we need to get back to following the law.
I agree 100%, but we've already been beaten on that in Montana by
Oh,
our
I
own
know, by our own people.
Yeah.
I know,
Yep.
that's pretty sad. Yeah, we just have been dealing with Forest Service. Forest Service protested our water rights because we are close to the Forest Service. And they had every right to do it because Montana gave them the right. Montana gave them a compact. So they have a say in the water now.
Did that get resolved, or is it still?
Oh, well, we've been at it a year. Yeah,
Sorry.
it's getting resolved, but yeah, it's very costly.
Yeah.
Yeah.
Very
Yeah.
costly.
Well, no one here is saying that's right. I mean, yeah.
Well, no, that's exactly right.
Well, thank you for listening.
Well, thank you very much, and Elena, do you want to come up? And
Yes, I'll come up.
Please. Thank you, and hey, I think we agree a lot more than we disagree.
Well, we certainly do.
Make sure you keep it on that one.
We just
How to get
have
to,
to stand
get to the end.
Yeah.
on it. This isn't working anyway. Well.
For the record, Elena
You
Gagliano,
want your stuff?
and this isn't on, so I'm
Yeah.
not.
It can be turned on.
It's, just push.
I think I could talk loud enough.
Okay, speak up, so Dick can hear you.
Okay, so for the record, Elena Gagliano. And another thing for the record, I noticed the newspaper, Phillipsburg Mail, is in here. Apparently they got their one-sided explanation. And just to say, if I was buying a car and I went to a used car dealer, and I'd ask the salesman about something, and I'm not sure, I wouldn't say, can I see another salesman from the same line? And that's basically what this is about. Okay? I know time is kind of limited, so I have a packet I'm going to go over, and I want to submit this for the record, and I want it to be included with the minutes
Okay, thanks.
for today. The first thing that's on there is a letter. You're talking about Flint Creek Hydroelectric. And back in 2008, FERC wrote a letter to the tribe. Now, why would you think the tribe would have any interest in the Flint Creek Hydroelectric plant? Well, they did with the licensing. Okay? You may want to check that. The reason why I bring that up is because you know we're having a problem with the licensing for that, as well as the contract with hydroelectric. Now, could you imagine if the Indians decided to come in on this? And they can at any time. Okay, so you may want to look into that. And I know it's been said a number of times, the contract with hydroelectric, the licensing with FERC, was a big joke. Yes, it was. And who handled it? A bunch of lawyers. And that's all we have. Lawyers who give their own interpretation of what's right, what's in the law, and everything else. A friend of mine sent me this. And he mentioned, quote, I still have not heard a legal justification for why the tribes are being gifted 90,000 acre-feet of water out of Hungry Horse Reservation. They didn't finance it. It wasn't built for them. It's not on the res. It's not necessary when the purpose of the res is considered, and it won't take them long to claim power from the dam in another give lawsuit. My remark is if the client, and I think Linda said it, if the tribe can claim this with Hungry Horse Reservation and other off-res co-ownership claims, why not the same with Rock Creek and Flint Creek? Okay, now, in that packet, there is, I'm not going to read the whole thing, there's a letter from Verdell Jackson. He was a former senator and representative, Montana. Very interesting. The Blackfeet Water Compact was passed by 75% of the vote. There are 7 tribes. in Montana, all having water compacts. All the 6 of the previous compacts met this requirement with no one, and no one had to give up any water. When the CSKT compact came up, it only passed by 3 votes. That's unconstitutional, right there. It passed 53% to 47, not the required 67% of votes. So there's a problem. Okay, let's see. S 3019, quote, "The tribe may use, lease, contract, exchange, or enter into other agreements for the use of water. If the city of Missoula needs more water out of the Clark Fork, CSKT will sell it to them, or not." This is not the purpose of the Federal Reserve.
That's not correct.
I'm sorry, I've got the floor right now, and then you can have it again. Next, the Hellgate Treaty. The Hellgate Treaty is a peace agreement between the CSKT and the federal government. It does not guarantee any water. It does not mention water or water rights. It's getting late. I mean, there's so much of this. It's all highlighted. And I'll just read this one more. The reservation already has the water needed to make the reservation productive. But the tribe has filed 10,000 water right claims throughout Montana as a threat. I think one of the good reasons why we should pass the Daines Tester CSKT bill, water bill, is because if we don't, you're going to be sorry. Well, I'm sorry. I think other people are going to be sorry. The government's going to be sorry. Because we are going to. And there's a movement that if Daines and Tester, forget about Tester, Daines and Jean Forte and Tim Fox go along with this, they are not getting our votes. The last one. The 1,500, in case you didn't know, 1,500-page Senate Bill 262, which is in our Montana Codes Annotated, all they've added is 65 more pages. The S 3019, that's the Tester. That's the Tester Daines bill. Okay? It has not changed anything. And were written, quote, by lawyers who did not follow the Hellgate Treaty or federal and Montana constitutions. It doesn't matter where you live. Quote, this is Vidal Jackson. I am sick and tired of the corruption and lies, especially the ads on television. Oh, that's another one you should see. There are problems on the CSKT reservation that need to be solved, but throwing $55 million from the state and $1.9 billion federal dollars and thousands of acres of feet of water is only going to make things worse. And as far as that commercial that we see, thanks Senator Daines and Senator Tester, you know who put that out? Well, there's a little group called Mercury LLC. And who's the chair of that? Denny Rehberg. Does that ring any bells? Denny Rehberg. And by the way, when the CSKT needed a lobbyist to get this thing passed in 2015, they hired Mercury LLC. So again, for the record, that's what you got. I'd like to see you rescind that letter. I'd like to see a letter from the commissioners stating we are not for this thing. And one other thing. I haven't been able to verify this, but Lake County commissioners are going to have a meeting March 11th at 6:30 to discuss the Daines bill. And Daines and Tester office, I believe, are going to be there at 6:30. And once I verify it, I'll let you know. And the other thing
What's the date on that?
March 11th at 6:30. And the other thing, because Lake County is definitely against this thing, and there's also a letter from them that's in that packet. They don't like it. They're going to go over the 64 pages about the Daines bill because they do not like it. And I think we should put this on the agenda again. And I think rather than having this person on the phone who can't answer any questions, he's been doing it at other pachyderm meetings, I'd like to see people here. Thank you.
So Ron, were there some things you wanted to answer to Elena's testimony?
I guess one of the things that I will address is, the concern about the tribe selling water to Missoula. The tribe gets a 599,000 acre-foot consumptive water right from water on the reservation. That is its compact right. Now that's very comparable to what the Crow got, over 600,000 acre-feet of water, and that's a consumptive right. That's what the tribe can use, can sell, but the water in the Clark Fork, particularly, Missoula and then upstream, and all the water off the reservation is non-consumptive. So it only can be used to maintain fisheries. So the tribe can't, use or sell, water from Flint Creek. It has to be left in the stream to protect fisheries. And as far as the Hungry Horse entitlement goes, I think it's important to remember that there's 3.6 million acre-feet of water in Hungry Horse Reservoir. That 90,000 acre-feet of water is currently used by BPA, Bonneville Power Administration. It's sent downstream for flood mitigation and stuff. It usually ends up in Oregon, Washington, and whatnot. Basically what this does is the bill does this. The bill does this. It gives the tribe that water right for that 90,000 acre feet, but it also stipulates that water has to be used within the state of Montana. So it cannot, that 90,000 acre feet can't leave the state. It has to be used in Montana. So that's what I'll say to that.
Is that a consumptive right, that one? Or non-consumptive?
Yes, the 90,000 acre feet out of Hungry Horse Reservoir is a consumptive right, yes. And that's part of that 599,000 acre foot number.
Okay.
So one quick clarification, Elena, I did get and I have been talking to Chuck Jarkey of the Lake County Commissioners, and they have 5 issues. I think one of those are the same issues that we have. One is ceding the bison range to the Confederate. The other one is acquisition of Montana state-owned lands within the reservation. The third one is acquisition of CSKT, more free, simple land. It's also on the reservation, and they're worried about, if the land goes there, there won't be taxes paid on it. Number 4 is the redefining of the term reservation. So that is one of our issues. And the 5th one probably is an issue for all of us, and that's the requested funding for the $1.9 billion. Mm-hmm. So, this commission doesn't fundamentally have the same issues they have. They're on the reservation with that. They have different issues. And I said, I told Senator Daines when I met with him in Great Falls, look, I'm looking out for the people that I represent. I'm looking out or trying to look out for the off-reservation water users in the Rock Creek and Flint Creek Basin, period. Okay? These are guys that are worried that under the original compact that they're going to have to go to court to keep their water. And they were, right. And if there's anything you can do to fix that, please try to help us. Well, he did. I mean, I think he did amazingly well. 97% of those waters are protected. Yes, there's some young rights that aren't protected, that's part of that 3%. You know, it's just the best deal I think he could get.
Well, if that was, since you're addressing it to me, if the compact was so bad, then it should have went back to get corrected.
Right.
Not that it goes to
Where does it go back to?
the
They
legislature.
passed this law. They passed it. We had our shot.
Oh, there's a lot of laws on the books. It doesn't mean they're constitutional. So we fight it, and that's what we didn't do before. We're going to do it now.
What is the mechanism to take it out of Congress and take it back to? I mean, I don't know. I'm just.
Well, I'm telling you, it's going to be lawsuits. And do you know, not for anything, because I don't like to be bipartisan, the majority of Democrats are gung-ho for this bill. Okay, I mean, I'm sorry, yeah, for the bill and the compact. Now, do they care about lawsuits? I don't think so. Do they care about people spending money? I don't think so, because look at all the rules and regulations that they tack on to the Second Amendment. Do they care that they're going to get sued? No, they pass these laws and bills. Okay, and that's how we fight it. If we've got it on the books, we sue them. And this is what's going to happen. We are going to sue them.
Who's we and how?
All of the irrigators.
Well, that's the issue they didn't want to take on.
Here's something in the Montana Constitution.
If you're raising cows right now,
Oh.
you don't have the money to buy a bunch of lawyers. This is a tough business. They don't have the ability to hire lawyers.
Oh, yes, we do. There's $55 million in the state.
You have water rights on Flickr?
You irrigate. What are you talking about? Irrigate means you...
I'm talking about the people that would have to foot the bill for the litigation you're talking about. And with absolutely no idea how that's going to turn out. It could turn out worse.
If this gets passed, it's going to affect everybody in Montana, not just Granite County or Lake. I'm going to read this one thing to you, and I'm sorry, it's going to be... This is the Montana Constitution, right? Compact, Article 1, Compact. All right, and it says, number 1, appended to the Constitution of the State of Montana and approved February 22nd, 1889, including the agreement and declaration that all lands owned or held by any Indian or Indian tribes shall remain under the absolute jurisdiction and control of the Congress of the United States, yada, yada, yada. So this, somebody who lives on the reservation said, looking at that, I live on their controlled land, quote unquote. So that should mean that I'm not under the state's jurisdiction. I'm under the federal government's jurisdiction. So he shouldn't have to pay 1 damn cent in state taxes. That's a good point now, isn't it?
And most Indians on tribes don't pay that. All right, so
A simple
go
question
ahead.
here.
Yeah.
I got this from Bullock. He sent out a questionnaire where a lot of people ask questions about the compact. Now, is the 97%, would that protect domestic wells? They give up all right to that if it passes, is that correct?
Isn't that right, Ron?
So yeah, so Article 3G, I'm reading it right from the compact. The tribes, on behalf of themselves and the users of any portion of the tribal water rights set forth in this compact, and the United States agree to relinquish their right to exercise the tribal water right to make a call against any water arising under state law whose purpose does not include irrigation.
Okay, my question is, and the question that they asked Bullock, if my well goes dry, can I dig a new well? And according to the compact, yes, you can. But if your well went dry at 50 feet, you're only allowed to dig another well at 50 feet. So that means they're still controlling our water. And this isn't so uncommon that our wells can go dry. My mother-in-law's well went dry. And she lived in her new house for about 5 years, and the well went dry. She had to go another 200 feet. Now, I wouldn't be allowed to do that. That means they still are controlling our water. Otherwise, I could dig as deep as I wanted to find water.
So now is that the state that's controlling?
This was they were asking questions about the compact, how we would be affected. And one person asked that, and I thought, that's not so uncommon for our well water to go dry. And it, you know, the way the aquifers are, you sink a well all around. Yeah, it's all 40, 50 feet, and if you go dry, and you're gonna put wells all over your place 50 feet? I mean, you'd have to move, you know, so it tells me they're still gonna control the water.
So this is, I guess can I ask you?
Yeah, go ahead.
Where is this coming from? This is something that, who said this?
Okay,
Again,
Governor
Bullock.
Governor Bullock put out a questionnaire on the compact. A lot of people had questions.
Okay.
And the state was answering what was in the compact, and they answered this. So we only get to go as deep as what we were, which is stupid, because if you don't have well water at 50, you're going to have to go deeper, and you're out of luck.
Because there is a difference when it comes to new wells, and this is, you know.
I'm talking old wells, not new wells, old wells. They've been there for 50 years.
But then they'd have to
to
drill a new one, right?
Oh, I see.
Yeah.
I suppose they put a meter on it too if it's a new well, huh? Yeah.
Go ahead, Ron, what were you gonna say on a new well?
I guess I was going to say there's a difference in, so, you know, if you want to dig a well, you know, you can still, you know, if you're off the reservation, you still go, you still go to DNRC or whoever gets permit. But you know, there is a difference. You know, if you're on the reservation, you know, it's a you know, a unitary management board that you know, oversees that process on the reservation. So there would be a little bit of a difference between off reservation and on reservation if you know, if you're going to dig a new well.
Okay, it sounds like they still have control then of our wells, our domestic wells, then, through this compact. And what happens if I can't get water? You know, if I can only go 50 feet down and I don't get water?
I think you misunderstand it. On the reservation, you go through a different bunch of people. Off the
Right.
reservation, you go through the state like you do right now.
Yeah, well, this was off
DNRC.
state. This was off state, this law.
Yeah, I read the
This
same
was off the
thing.
reservation.
Well,
Yeah.
there's people right now in Granite County drilling wells that are a lot deeper than 50 feet that have been authorized by the DNRC right now.
That they can only go 50 feet?
No, the DNRC lets them go find water. But we don't go through the compact or on the reservation to decide whether or not we get a well. We go to DNRC. State DNRC has rules about, you know, how close it is to the septic or anything. And then they say, sure, go for it. There's no rule like that.
But
Yeah, I read the same thing she did.
yeah, the
Can't remember
DNRC
what it
would
was.
control this. And after this compact, you know, they would control it.
Okay.
Only the level. If you got well water at 100 feet, you can dig another one for 100 feet. If it's
I'll do
50
some
feet,
research on that, too.
50
Yeah, we'll have to
feet.
look
I
at
should have brought that in and
First
showed it
time
to
I
you.
heard
But
of
this came from Bullock.
But that's not in the compact.
These are questions people are going to ask how the compact would affect
So
them.
consider the source, but we'll look at it.
All right, I should have brought that in. I thought it wouldn't be important,
Come
but,
on.
yeah, okay. Well, that's the only question I was wondering, so.
Okay, good question. Is there any other questions or thoughts? How about questions for Ron?
Hey, just FYI, everyone,
I did show that.
I do have to hop off here in about
Okay.
10 minutes. So.
Okay. So Dick, do you have a question for Ron specifically?
No, I don't have any questions for
Okay.
him.
Okay, does anybody else, first of all, have a question for Ron before he has to hop off? Thank you, Ron, it was informative.
Yeah, thanks, Ron.
All right.
Thanks so
Thanks,
much.
everybody.
Okay, you take care.
All right.
Bye.
It says it was
Mr. Meyer.
put out by a law.
I'd like bring up the points on the Verdell Jackson letter to the Northwest Liberty News. There's some very important point that I think that you brought up when we went to the legislature and fought that the compact or the legislation that was being passed at that time. The fact of the matter is that legislation was a constitutional issue, and it should have been passed by a 67% vote. It was actually passed by a 53% vote. So in effect, it didn't pass the standards for the legislative test. The other thing is that when you look at the water compact and the water rights that the Indians had, they had the right to hunt and fish in the waters of Montana. They didn't have any water rights that extended beyond the reservation. Therefore, they don't have the ability to, or the standing to give away something that they don't actually possess. So, if that's the case, they effectively passed a piece of legislation. As far as I know, the legislation is covered by Montana Code 85, I think it's 1901, and the administrative rules are 1902. In those, when I was at the legislature, I didn't observe anybody reading the damn thing. It's 49 pages long as far as the compact is concerned, and it's another 60 pages long as far as the administrative rules are concerned. And to my knowledge, the lawyers, as she stated, didn't even read the Hellgate Treaty or any of the previous things there. But those pieces of legislation were passed, and as you're saying, they're the rule of law at this particular point in time. And it's supposedly to alleviate the possibility of going to court over this issue. In my mind, they should be going to court over this issue because we shouldn't be paying 1.9 million federal dollars and 50 million state dollars for something that they don't own. It would be like you selling me, you're going to sell me a car for $50,000 and you don't own the car. That's not a valid contract, and it should be illegal on the basis. The compact, as it's written, again, in my mind, it should be challenged as being unconstitutional. The water people with irrigation and water rights are going to have to challenge this, just the same as it was challenged in the last 30, 40 years in the water court. The water court made a disposition of what the land rights were, and that disposition should stand. As it sounds now, they're going to set up a water court for the tribe. The tribe is going to be the one that determines what the payments are, what their rights are, and what they're going to extend water rights to you, and they're going to determine what you're going to pay for it. So effectively, we've got another administrative nightmare, and it's going to wind up in litigation no matter how you look at it. If you can read that statute, those two statutes, and know what's involved in that, and then also set up the administrative procedures for that. I wouldn't doubt that they're going to have to hire 20, 30 people in order to just administer that thing. And the council, the CSKT council for the water board is the one that's going to make the final decisions on what's going to be law and not law. So I think effectively passing the CSK compact and amendments provided by Senator Daines and previous tester, to think that we're not going to have litigation over that is to think that they have rights to give away is not so. And if you look at who's going to administer it there, you're going to have to go back to the Department of Interior and to the Department of Justice in order to get some kind of a ruling on whatever the hell you're debating. So I think it's inevitable that you're going to have litigation on this thing. I think that your experience with the FERC up at the hydroelectric dam should give you a pretty good lesson in terms of how the federal government is going to deal with local water situation. They're going to determine what they want done. They're going to demand that you want done. And in the case of FERC, if you don't comply with what they want done, it's going to be a $22,000 fine per day. So in my estimation, again, we're giving up our water rights. It's going to have to be contested in the court. And I think from your standpoint, you should be contesting the water rights of FERC in the court. Thank you.
So, just so you know, Dick made this same point pretty eloquently at the legislature about they're taking property that doesn't belong to them. And you did, and I agree with that, but the legislature passed it, okay? You know, here we are. So, one of the things I liked about Daines' amendment to the bill is that we don't have to deal with, yes, there are going to be all kinds of lawsuits, but we don't have to deal with them in federal court, there'll be state court issues. So it brings it back into an arena where a rancher really could drive to Helena, Great Falls, Missoula, and put on a case. If it's left as it was passed on the legislature, all that would be a federal court, which could be Seattle, who knows. And so that is one little bit of a Daines change I like, is that those water disputes are going to have to be handled in state court.
Do you have a copy of the Daines proposal?
Yeah. I don't have a clean copy. You got a clean copy?
I haven't been able to find one.
I do.
Yeah.
No.
Anyone else want a copy of it?
Yeah.
Give that to Dick.
Is
Is that the 65-page proposal?
Yeah.
Well,
Let me double check how many pages it is.
Do you have an extra one, or?
65 pages. I'll make a copy of this.
Oh, good, I would love one.
Back one.
I have it.
You do it.
Yeah, I would like it.
Anyone else?
Well, I haven't seen any comparisons between that and what actually went into the law.
Sure. So
it's really hard to
as you read that,
talk about it.
as you read that,
Senate bill itself?
it will refer to appendages in the original
Do you want a copy of it?
CKSD bill, and you'll find that on the DNRC web page. It's right on the front page, and it says CKSD water appendages. Okay. So there's two appendages that, when you're talking about authorization, water rights, you want to pay attention to, so you have to read the whole thing, is 28 and 29. So they specifically mention these basins, rock, cricket, and flint rock, okay? And you won't find that in that bill. There's a reference to it, but then you'll have to go to DNRC and look at the appendages, okay?
Well, I think that's one of the problems with it. They're always referencing something in some other pack, some other thing, and you really have no idea in hell what they're talking about. And based on my experience with lawyers, they can make that come out to mean whatever they want it to mean, and what you think are your rights, and what the rule of law is totally beyond your control. The way that water court for the council for the tribe is set up, you don't have any rights whatsoever in that. And they, as she said, they have the right to give you the water rights, or they not give you the water rights. And so you really don't have any control over that. And there's, I don't know whether there's any place that you go other than the court to challenge that. And, effectively, you're negating probably 40 years of water court.
Well, this basin's been closed since sometime in the early 90s. So
yeah.
Thank you, Dick. Anybody else? Anybody else have any comments?
No, just that I think it should be on the agenda again, and should have some of these people, rather than on the phone, some of these people from Daines' office, Tester's office.
Ron is actually the guy who did the research and did most of the negotiations, so he's unable to be here, but he did say he'd come in on the phone, and I thought he gave us a pretty good couple hours. So.
Yeah, he did, but he wasn't. It's one thing to read from a script, and that's what they're doing. It's just scripted. They're all saying the same thing, and I want the details.
Thank you. Anybody else?
Thank you.
Do a Google search for that bill as well. And search actual language of Montana Water Right Protection Act, and it'll come up.
Don't forget, we have the annotated.
Oh, you do?
Oh, yeah. Just like the United States Constitution annotated. That's an eye-opener.
Yeah.
Did you get that 85, 19 or 20-1901, 1902?
Is the only.
That statute? Yeah, I'll look at it.
There's two statutes. Well,
I'll tell Michael you're gonna be here.
you can make that mean anything you want it to mean.
Thank you.
There's definitely some ambiguity in some of that stuff, I agree.
Did we take up your time? No. You're fine.
That's gonna